the State House now, lawmakers are considering a bill that would reshape child custody laws here in the Palmetto State.
And supporters say the bill is necessary because our state's laws make it impossible for some parents to get partial custody, but others say it could have unintended consequences. Right now, News 19's Josie Frost joining us from the State House with this report.
The bill comes down to one simple idea. Parents would get 50-50 custody over their kids unless there's some major reason not to. Supporters of the bill are calling for reform to South Carolina's child custody laws, saying those laws unfairly favor one parent over the other. But opponents of the bill say it goes too far.
Why wouldn't we want to keep parents and children together if they're able, willing, and fit parents? Why wouldn't we charge the hill for that?
Gil Gatch is the sponsor of the Equal Parenting Act and a family court lawyer. In South Carolina, judges decide custody arrangements solely on the child's best interest. That means they consider things like which parent has been the primary caretaker and the relationship between the child and parent and come up with a custody schedule. But there is another factor that complicates these agreements for judges. Under existing case law, there is a presumption that 50-50 custody is not in the child's best interest. Gatch says all this means that judges typically aren't able to grant equal parenting time, even if they want to.
The case law today in South Carolina family courts doesn't allow for the judge to say, you know what, I'm going to give 50% to you and 50% to you. It doesn't allow for that. There has to be something called extenuating circumstances in order for the judge to do that.
But his bill would create a new rule called a rebuttable presumption for equal parenting time. That means that in these cases, parents would automatically get 50-50 custody. And if the judge wanted to deviate from that and give one parent primary custody, there would have to be some evidence or reason why.
It puts the court in the position to justify why one parent is not allowed to be with the kid equally. And that parent then has the opportunity to challenge it through the appeals process.
But opponents of the bill say that could tie judges' hands in a different way. Jennifer Creech is a family law attorney.
Our family court judges should be allowed to hear the facts and make a determination as to parenting schedule that they believe is in the best interest of that child.
She says the current law should be changed so judges can grant equal custody if they want to. But creating a new rule that judges have to follow will just complicate these cases more.
I think when we start taking away the discretion of the family court, who's hearing those case-by-case facts, that we're really not considering the needs of South Carolina's children. We're forcing them into a mold, and sometimes they just don't fit.
Now, there is a separate bill that removes any requirements for judges to award either joint custody or sole custody. It gives judges sole discretion over these cases. Lawmakers are looking to make amendments to both bills before advancing them any further. Reporting at the State House, Josie Frost, News 19, WLTX.
All right, Josie, thank you so much. And both bills are now still in committee over in the House.